Hello and welcome to this podcast series on the new European General Data Protection Regulations, the GDPR. My name's Steve Lofthouse, a GDPR specialist with the Proceed Group, and in this series we're going to be looking at the various pieces of SAP software that will help companies in their journey to becoming GDPR compliant and maintaining that compliance moving forwards. Now, it's important to remember that the GDPR is both mandatory and demonstrable. You have to be compliant and you also have to be able to demonstrate compliance. And all the software tools we're going to be talking about in this series are going to enable you to do that. Now, so far in this series, we've talked about SAP's Information Steward, which is a data discovery program, which is going to allow us to find the data within our systems and classify what kind of data that is, measure the quality of that data and put in place business rules to ensure that moving forwards we only have high quality data in our systems. We've also looked at SAP's Information Lifecycle Management software, which is going to help us with data discovery in our live and archiving systems. It's going to help us with data deletion requests, data blocking requests, and it's going to help us where we have to hold data for legal reasons. Now, in today's episode, I want to talk about SAP's Process Control software. And Process Control is quite an important piece of software because it's process control that is going to allow you to demonstrate compliance with the regulations. Now, at the end of this podcast, I've got a little bit of a challenge for you all, and I wonder how many companies will balk when they hear my challenge. So, what I'd like to do is wander through a few different scenarios and talk about where process control fits into those various scenarios. Now then, the first one is a subject access request. Okay, so as a data subject, I am entitled to request a copy of the data that a company holds on me. And I can do that in the form of a subject access request. Now, it's interesting to note that I can, as a data subject, supply a subject access request in any form. I could tweet a subject access request. I could send it via Facebook message. I do not have to write a subject access request out on a letter. I do not have to fill in a specific form. I can just tweet it. I also do not have to serve a subject access request, if we put it like that, to the data protection officer. As long as I've sent it to the company, it's legally applicable. So I'm going to tweet a subject access request to a company, and that company then has to fulfill my request. So you can envisage, as a company, the subject access comes in as a tweet to the customer-facing internet help desk or whatever desk you have monitoring your Twitter feeds. And the people on that desk then have to recognize that as a subject access request and take that subject access request and pass it on to the relevant person, maybe the data protection officer, the person that's going to act upon that request. Once let's say the data protection officer receives that request, they then have to trigger that data discovery process, go through the business systems, the live systems, the archiving systems, the log systems, and assemble my data. The EU GDPR does not make any specification with regards to how far back historically data discovery has to go. So I am entitled to all my data, no matter how far back in history it goes. So there is a degree of reasonability and proportionality to that, but generally speaking, there is no historical time limit. So I've sent my subject access request in via Twitter. It's eventually found its way to the data protection officer. He's now triggered the business process for data discovery. He's now discovered and assembled all of my personal data. That data is assembled in an electronic form, an electronic data package, let's call it. We don't have to put it in an electronic form, but the GDPR requests that where possible we do. So we assemble that into an electronic package and we ship that back to the data subject. How long did that process take? how can we prove to the Information Commissioner how long that process took? Do we expect people to fill out a form? Do we expect our staff to fill out a form of when they received a data protection request? Who's going to fill that form out? If I've sent it in by Twitter, does the subject access request start when you receive the tweet? Because to my mind, as the data subject, it does, because I've sent the request in. From the corporate point of view, it might start when the data protection officer triggers the data discovery process. So there's already a degree of discrepancy there. So we need to be in a position to prove to the Information Commissioner that we've answered this subject access request in a reasonable time frame. The GDPR specifies a reasonable time frame, and that is taken to mean 1 month, which is a reduction from what the legislation used to be. So within a month we have to respond to these things. If we cannot supply all of the information, then we need to respond to the data subject explaining why we can't answer their request within a month, and we need to make sure that we've recorded that, because we're going to have to prove to the Information Commissioner that we responded to the data subject that we couldn't meet the 1 month time frame, and this is why. And this is where SAP's Process Control software comes in. So Process Control software, generally speaking, operates in 2 ways. We can either ask the Process Control software to go out into our IT system and run reports and interrogate the system, for want of a better expression, or we can place control objects within our business processes and our data processes, such that when that control object is triggered, it pushes information into SAP Process Control. Now, to my mind, it would seem logical that when we construct our data discovery process, we embed SAP Process Control objects within that data discovery process. So, when we receive a subject access request, we can trigger the data discovery process, and at that point the control object pushes into process control that one of these processes has been triggered. And when we gather the data, assemble the data package and ship that back to the data subject, we can put in place another control object so that we can tell process control software that the process has now been completed. SAP Process Control has within it various business rules that we've built, one of which is red flag me if these processes are taking longer than a month. Brilliant. So now, as a data protection officer, I can see when a data discovery process is taking longer than a month, when a subject access request is taking longer than a month to answer. And the Information Commissioner can also see that. I can also show the Information Commissioner, I can prove to the Information Commissioner that I am hitting this 1 month time frame, and where I am not hitting this 1 month time frame, I can prove that there are justifiable reasons why I didn't hit it, and here they are. You can see we've tagged against this particular request that we couldn't recover that data within a month because we needed to go and talk to an external supplier, Iron Mountain, who was handling all our paper documentation. So it's enabling us to prove that we're sticking to this 1 month time frame by using these control objects that we've embedded within our data discovery process, our business processes. Okay, so that was quite a straightforward one because the data, it's in our company. What happens if we receive a delete request? Okay, so in that subject access request, one that we've just talked about, I mentioned an example where we didn't hit the time frame because we had paper documentation stored with an external company, Iron Mountain, and because of that, it took longer for them to go and find the paper documents and gather copies of them. So if we receive a delete request, the first thing we're going to try and assess is whether that delete request is lawful, shall we say. Do we need to keep the customer's data, this data subject's data, for any longer? Are there any legal holds which apply? Do we have to keep it for tax purposes? Are we likely to get sued in the future? If there are no overriding reasons, then we have to delete that data, and we have to delete all the data. Okay, so we need to record that. So, okay, well, maybe we trigger our information lifecycle management process to go off and find our data objects, our data archiving objects, data in the live system, and delete that. Oh, brilliant. Information Lifecycle Manager is going to do that in a provable way. It's going to do it in an auditable way. So we've got an audit log within ILM that shows that these particular data objects were deleted in a secure way. Well, we can use SAP Process Control to go and run a report, to go and audit those logs, to gather the log files in, analyze the log files, and identify where that record was deleted and the amount of time between the request coming in and that deletion process actually being carried out. So we can use process control to kind of go out and analyze log files and report back, as well as using these control objects to push data in. Now, I mentioned that we'd got records stored in Iron Mountain that pertained to this delete request. It is our responsibility as a controller to ensure that those records stored with our external contractor are deleted. It is our responsibility, and it is our responsibility to prove to the data commissioner, the information commissioner, because we are the data controller, that has been done. And process control gives us a way to record that. If we were using a third-party processor who was, for example, using an SAP system, so maybe we contracted with a third-party processor who was using some innovative software, innovative statistical algorithm developed in R, sitting on a nice SAP HANA appliance in their offices, that would run route planning and take into account weather and traffic and road conditions and all these amazing variables. If we were using them and they held some of our data, we could use SAP Process Control to audit and to monitor the deletion process within their systems. All we need from SAP Process Control to do that is to be able to access that system. So all we need is a username and password, and we can plug in the third-party supplier systems into ours, and we can set SAP Process Control off monitoring them as well. So we can kind of extend that chain of compliance, for want of a better expression, into the systems of our third parties, because we don't have to be sat on, they don't have to be sat on SAP systems. So we could be running process control, and we could be running that against our suppliers who are using an other data product. Maybe our plugin for Iron Mountain is just a form. Maybe we're just exposing a web form to Iron Mountain, and the reason I say that is because they're paper-based records that Iron Mountain are holding for us. It's not as if we can trigger the deletion of those records electronically. We need somebody to physically go and find them, shred them, or physically go and find them and photocopy them and whatever. So maybe we're just pushing a web form out to Iron Mountain for them to complete once that data destruction process has been done, and that web form pushes data back into our SAP Process Control system. So we can prove to the Information Commissioner that we are hitting these time frames, and we're hitting those time frames across our compliance process. be that within systems that we control within our own company, be that within systems that we're contracting from our third-party processors, and even be that systems where the data is in a physical form, be that paper or microfiche or something like that. So it's quite a useful piece of software in that sense. You can envisage looking at a computer screen with a dashboard on it that we've built out of this process control data. The process control software is going to allow us to do that, where we can build this dashboard that's essentially going to be a data protection officer's dashboard, and it's going to show us these compliance metrics and how many of these requests are being completed within a month and things like that. Now, one of the other requirements within the GDPR is these data protection impact assessments. And a data protection impact assessment should be completed. Essentially, it's a risk exercise, but it should be completed for any process where it has not been completed before, or any new or changed data process. So initially, DPIAs are going to be a big workload, because initially no company is going to have a DPIA assigned against a data process. The process control software from SAP, this is where this software is genuinely useful. So we're going to first develop our documentation around data protection impact assessments. And that documentation is going to go through a number of different versions before, as a company, we're happy that we have a standard version. The process control software is going to keep track of these different versions. So first of all, we can show the Information Commissioner the evolution of this documentation. Next, having got our DPIA, our Data Protection Impact Assessment documentation just the way we want it, we can push that documentation down to the people that need to be filling these assessments out. So we can use process control to push that documentation out and receive it back. And having received it back and assessed it, we can tag that data protection impact assessment against that data business process. So we can tag DPIAs against the various data processes. Brilliant. The Information Commissioner wanders through our door, because the Information Commissioner gets the power to do an unannounced audit in the GDPR. So the Information Commissioner walks through our door and asks to see DPIAs for every single data process within our company. We can show them. And you can see which impact assessment applies to which process, because it's tagged, it's virtually tagged against that specific process. Brilliant. Our ability to audit all of our processes and prove to the Information Commissioner that these impact assessments has been done, that we're hitting the compliance timelines, has just gone through the roof. It's brilliant. Now, the other thing about these DPIAs is you need to do one if a process changes. Process control is going to flag that up. Process control will flag up that the data process has changed and that you need to redo this data protection impact assessment. Brilliant. So we can get notification when processes change. We can push out DPIAs to the relevant parties again, and we can have those filled, we can review them, and we can tag against the various data processes. So we can keep these documents up to date and relevant and tagged against the relevant business processes, and we can prove to the Information Commissioner that should a process change, it will trigger the need for another DPIA. Now, one of the other things within the GDPR is breach management. And in some ways, breach management is essentially it's following a policy. How you manage a data breach is just following a policy. There isn't any real business process behind it as such. Now, process control enables us to follow that policy in an interactive way. We can indicate when the various steps within that policy were completed, why there were delays in completing those various steps. There are various criteria around breach reporting, but essentially, a data breach has to be reported to the Information Commissioner within 72 hours, and if you go beyond that, you need to have a very good excuse to give the Information Commissioner. So process control is going to enable us to follow the breach policy, record when we're completing the various steps, and also record why, if things are taking longer than we expected, or why we've decided that actually, do you know what, we don't need to notify the Information Commissioner or our customers. Our data was stored in a highly encrypted format and is thoroughly useless. Therefore, we don't need to record that. We don't need to inform the Information Commissioner. We would want to record that fact. We do need to be in a situation of being able to prove the decisions that we've made, prove the reasoning, justify for why we've made the decisions that we did. And process control gives us an opportunity to record those decisions, gives us a central place to be recording the reasons for taking these various decisions. So, SAP Process Control is kind of fundamental in our ability to prove to the Information Commissioner that we are compliant with the GDPR and we are maintaining compliance. We're hitting timeline, we're ensuring that protection impact assessments are done, and this kind of thing. And the challenge that I would give companies is that when you are undertaking GDPR projects, your mentality should be that at the end of the project, when you've reached compliance, when you've achieved your compliance benchmarks, you should expose your data protection officer's dashboard to the Information Commissioner. Now, don't get me wrong, I appreciate that the companies won't do that, and there are a whole raft of business reasons why that you wouldn't want to do that. But that is a useful mindset to adopt, that as a company we should be operating in a manner where we have absolutely no problem with the Information Commissioner seeing this information. We're comfortable that we are in compliance, that we can prove compliance moving forwards. Because essentially, if the Data Commissioner, if the Information Commissioner decides to do an audit, and as we've already said, the GDPR empowers Information Commissioners to undertake audits at any point in time unannounced, then we should be in a position at all points in time to be compliant. So adopting the stance that we are going to expose our Data Protection Officer's dashboard, we're going to let the Information Commissioner see our metrics on a 24/7 basis, would be a healthy mindset to adopt moving forwards. I hope you found that useful. There are more of these podcasts coming up, and as well as these particular podcasts, we do have a blog series running, and that series is aligned to the Information Commissioner's 12 steps, and we've used our knowledge and experience of working with SAP and SAP data, and our knowledge and experience of the GDPR projects and various other bits and bobs to I hope you found that information useful. There are more of these podcasts coming up, And as well as this particular podcast series, we do also have a blog series running at the side, and that series is aligned to the Information Commissioner's 12 steps. We've used our knowledge and experience of working with SAP and SAP data, and our knowledge of the GDPR and working on GDPR compliance projects to produce a blog series which has more meat on the bones. It's not designed to scare you. It's designed to help you in your projects to become GDPR compliant. So I would encourage you to check out that particular series. There are some interesting nuggets within it. The easiest way to find the blog series is to use your favourite internet search engine and search for proceedgroup.com GDPR. My name's Steve Lofthouse. Thank you very much.